Good afternoon, everyone, and thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those of you who are here early, thank you for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody, and thank you for joining us for today's online talk entitled Reinstating a Struck-Off Company. My name is John Chan. I'm a senior associate with Mao Wing-Kwai & Associates, and I'll be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Mao Wing-Kwai & Associates is a mid-sized law firm that was founded in 1985 by Dato' Mao Wing-Kwai. Our team today comprises of 24 lawyers and a support team of 19. Dato' Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. And the firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment and industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWK online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. This is our 11th talk in our online talk series for 2021. And before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. We have two speakers for today. They are Ryan Cheong and Mr. Gan Chong Chie. Ryan will be speaking first on what is a striking off of a company and how do you do so. And Gan will be speaking on how to reinstate a company which has been struck off. After that, we will then conclude with a Q&A session. Firstly, allow me to introduce Gan. Gan is a partner in our dispute resolution department. He graduated from the University of London and has a master's in international economic law from East China University of Political Science and Law. He was admitted to the Malaysian Bar in 2009, and his practice areas include probate and administration, banking litigation, arbitration, and construction. Next, we have Ryan Cheong. He is a paralegal who is waiting to be called to the Malaysian bar and is part of our dispute resolution, construction litigation, and corporate litigation departments. He completed his pupillage in the firm in January 2021 and graduated from the University of Reading in UK. His areas of practice include general litigation, construction litigation, and arbitration. These are the talk points for today's talk. If you have any questions, please don't forget to post it up on Slido. You can access the Slido page by scanning this QR code or going to the Slido website and key in the number 462824. Okay, and so without further ado, I will pass the presentation to Ryan to start.
Hi, good evening, everybody. Welcome to our online talk today entitled Reinstating a Struck-Off Company. Now, before we dive into the main topic of today's talk, I think it is important for us to discuss what striking off is and how a company can be struck off in the first place. What is striking off? First and foremost, striking off is a process whereby a company is removed from the register of companies in its entirety. So, in other words, when you strike off a company, the said company will cease to exist and will be dissolved completely. So think of it as the death of a company, essentially. So striking off is governed by Section 549 of the Companies Act. There are a few grounds in which a company can be struck off. The first ground and the most frequently used ground is when a company is no longer in operation. This means the company has no more business transactions, is no longer involved in any negotiations with clients, and is not carrying out any correspondences with anybody whatsoever. The second ground in which a company can be struck off is when the company is being used for unlawful purposes and has contravened the provisions of the Companies Act 2016. An example of this could be when a company is used as a front, unlawful conduct, and impropriety. Now, the third ground in which a company can be struck off if the affairs and the assets of the company has been fully wound up. What this means is the company is now a shell of its former self, it has no assets, and it has nothing to offer anymore. So these are the three most common grounds in which a company can be struck off under the Companies Act 2016. Why would a person want to strike off a company when there are so many other methods of dissolving a company? Well, first and foremost, striking off is very expedient, it's cost-effective, and it's much more straightforward than other dissolution processes, such as winding up. You don't have to apply to the court, you just need to apply to the Companies Commission of Malaysia with an application form, declaration. It's very straightforward, and it's really ideal for companies that are dormant in the sense that there are no more business operations and there are no more transactions going in and out of the company. It's ideal for these companies to be struck off if a member of the company doesn't want to carry on with the business anymore. It's also an ideal solution for companies which are free from liabilities and debt. It's easy to strike off such companies, and striking off is ideal for people who no longer want to pay any administration fees or pay any money to upkeep the company. It's easy for these companies to be struck off. In the slide before, we mentioned that an ideal company to be struck off is a company that is no longer operational and is dormant. It has no transactions going in and out, and these are the most ideal companies to be struck off. So to determine what operational is, we can look at the case of RDS Bina Sendirian Berhad against Ong Chin Ho and another. In this case, the court held that operational in the striking off sense would mean a company that is still engaged in negotiations and correspondence, even though there are no business transactions. What this means is that if your company is still engaged in negotiations and correspondence, although no transactions are going in and out, although no business operations are being carried out, it can still be deemed operational and is not as easily struck off, and you will not fulfill the first ground to strike off a company. So if you intend to strike off a company, it would be ideal if no more negotiations and correspondences are being exchanged with potential customers, past customers, or whoever it may be. So that is striking off. Now, how do we strike off a company? I'll deal with that now. For most, who can strike off a company? The persons that can strike off a company are listed in Section 550 of the Companies Act 2016. So the first person who can strike off a company is actually the Registrar of Companies. The Registrar can strike off companies on its own volition if it finds that that companies are no longer in operation, companies are not doing any more businesses. Most notably, and the most frequent ground for a registrar to strike off a company is when it has come to their attention that a company has failed time and time again to file annual returns each passing year. If this is a prevalent issue, registrar will take it upon him or herself to strike off the company. The second class of persons that can strike off a company is a director, shareholder, member, or a liquidator of the said company. These persons would want to strike off a company for the same reasons I mentioned earlier, in the sense that they do no longer want to pay the administration fees of a dormant company. They do not want to upkeep the company anymore, and these people can strike off the companies. Before an application can be sent in to strike off a company, a few requirements must be followed. The first requirement is that a shareholder resolution stating that the company is no longer operational and has no business transactions is necessary. So the shareholders have to sit together and pass a resolution stating that there are no more business transactions going in and out of the company. And once this has been fulfilled, the first requirement will also be fulfilled. So the second requirement is to ensure that the company has no more assets or liabilities. This can be done by filing in with your application form your latest financial returns showing that the company no longer has any assets or liabilities. In the case of a company that has not even begun business, has not even been involved in transactions, what you actually do is you have to show the Companies Commission of Malaysia that there is no active bank account related to the said company. If there are no bank accounts, transactions would not have been started and there are no assets and liabilities. That is the second requirement. So the third requirement is to ensure that the company has no outstanding charges, penalties, or compounds. These charges, penalties, and compounds can come in any form, and you just have to make sure that none of them are applicable to the company that is being intended to be struck off. So the fourth and very ironically important requirement for a company to be struck off is that the company's information must be updated within the register of companies. Oftentimes when companies' information is not updated within the register, when an application is given in, the registrar will actually contact the representative of the company and tell them, hey, look, the information is not complete. You will have to complete it and update it for us to actually process your striking off application. So the other requirement is to ensure that the company has no outstanding tax or any other liabilities with any government department. The company must also not be involved in any legal proceedings. If you're involved in any legal proceedings, if you owe money, have liabilities, or there are creditors lurking around, it might not be advisable to strike off your company yet. And if you do not fulfill this ground, it's a hard no for striking off a company. Penultimately, a company must not have made any return of capital to shareholders. And lastly, one must ensure that the company is not a holding or guarantor company. So once these requirements have been fulfilled, the applicant will have to submit a declaration form and another form requiring you to take off all these requirements with a fee of 100 ringgit to the Companies Commission of Malaysia. These forms and checklists of requirements can be found online, and it's called the Guidelines on Application by Directors or Members to Strike Off the Name of a Company. It's very easily accessible. If you type it into Google, it'll come up straight away. So what happens next once a company is struck off? Once you made an application to strike off. So once the application is made, people will be notified, or associated persons will be notified of this application to strike off the company. So when this notification goes out, there is a period of 30 days where aggrieved persons can raise an objection to the striking off. And the grounds on objecting a striking off, basically that the company is still carrying on business, it's not suited to be struck off, the company is a party to legal proceedings, or there are debts and liabilities that have not been paid off yet. Another ground to object a striking off is that the company is in receivership or is in liquidation. And lastly, a person can apply to object to the striking off if they believe that there exists a right of action on behalf or against the company. So, for example, if the company is owed debt and wants to recover that debt, you can object to the application. Or if the company owes someone money, you can object to the application as well. After 30 days, if there are no objections, the company will cease to exist. Like I said earlier, this essentially means the death of the company. It no longer exists. It does not exist in the register of companies anymore, and it will no longer be able to conduct any form of business transactions. Its operations will cease entirely and more or less dead. Even though the company is struck off and is quote unquote dead, the liability of every past director, officer, or member of the company will continue on. So any past conduct of a director, officer, or member of the company which has not been enforced at the time of striking off can still be enforced in the future, even though the company has been struck off. So that's it for my part. This is what striking off is. And the next part about reinstatement of companies is essentially the revival of the said company. And I will hand over the mic to Mr. Gan Chongqie.
Thank you, Ryan. Thank you, John, for the warm welcome, and welcome everybody to today's topic. Let me share my screen. All right, so I will continue with where Ryan has left on the reinstatement of a struck-off company. So basically, like what Ryan has actually illustrated, the reinstatement of a struck-off company is what happens after the registrar struck off a company and we want to revive it. So what is the provision for the reinstatement of a company that has been struck off? Under Section 555, sub 1 of the Companies Act, it stated that any person who is aggrieved by the striking off of a company may, within 7 years after the company has been struck off, apply to the court to reinstate the name of the company to the register. So what exactly is this fuss all about reinstatement? So reinstatement of a company simply means that the company's name is returned to the register of the companies. In essence, this means that the company will once again be deemed operational and will be able to carry on business transactions and negotiations. This also means that the company can sue and or be sued. So who can apply for a reinstatement? Under the Act, it's provided that any person aggrieved by the decision of the registrar. And subsequent cases, which I'm going to flash on the slides, will show that not only directors or shareholders can actually apply to reinstate the company. Aggrieved person here, there's no clear definition. As long as someone is aggrieved, you can actually apply to have it reinstate. What are the usual reasons for reinstatement? For example, the company has undeclared and unaccounted debt or charges. There are unrecovered liabilities and or assets. Or for example, the company may want to bring a legal proceedings for an unlawful act discovered after the striking off. So perhaps, for example, after the company has been struck off, it was discovered that perhaps a certain director has misappropriated funds. So hence, the company would have to be revived in order to bring a legal proceedings. Again, these reasons are not exhaustive, and it could be any reasons as long as it's to help to basically bring back the company to life. So for example, like what I mentioned, the company directors can apply for reinstatement. What are the usual reasons? The striking off was done mistakenly, or to recover assets which were not declared in the striking off application. So for example, when perhaps the directors or the shareholders of the company, they applied to have the company's strike off, and subsequently was realized that certain assets, they have not been transferred and it's still under the company's name. Hence, this could be one of the reasons to have it reinstated so that they can do the process of transferring off the assets of the companies, or also to recommence business operations and transactions. Will a court carry out a reinstatement? Yes, and what's basically the test here? So under Section 552 of the Companies Act, a court may reinstate a company if it's satisfied that at the time of the striking off, the company was carrying on the business or was in operation, or if, let's say, for example, the company was not carrying on the business and it was struck out, it's just that the company be reinstated. Just here means fair, and justice requires it to be reinstated. So in ordering a reinstatement, the court may also give directions to place the company and all other persons in the same position as nearly as may be as if the company was never. So the court will do its best to put the position as if the company has never been struck out. So a case sample here. So in Green Links against Rohan Jaya Syarikat Malaysia, this was a case that was handled by the firm. Green Links was struck off by the register, from the register of the respondent, which is SSM, for its failure to file the annual return since 1999. But prior to the company or Green Links being struck off, Green Links was in the midst of litigation with another company. So the matter went from the High Court up to way to the Court of Appeal, not the striking out here, the litigation. And Green Links was successful in obtaining a counterclaim. Hence, when the matter went before the Court of Appeal, and then it was subsequently reverted back to the High Court for a trial, the company was struck off register. Green Links was struck off, and the firm represented Green Links to make an application to reinstate company. But take note, it was under the old rules, the old act, but the principles are equally applicable. In this case, the matter was decided by Justice Arif Yusof who was the former Speaker of the Parliament, the Justice Arif held that it was just and equitable for the petitioner to be restored to the register so that it could proceed with its counterclaim against the other company. In short, the courts are vested with the discretion to order the restoration of the company names which have been struck off, provided that it's equitable to do so. The next case that I would like to share is this case of Hemmelata against Springs Court Sendran Berhad. So Hemmelata and Spring Courts entered into a building agreement on 11 April 2000. So according to this building agreement, the vacant possession or Spring Courts was supposed to deliver vacant possession on 10/4 2002. However, the vacant possession was only delivered on 3rd of July 2008. So what happened was subsequently Springs Court was struck off the road on 31st of December 2009. So Hemmelata applied to court to reinstate Springs Court to the register of companies. The reason given was Hemmelata wanted to initiate legal proceedings to claim for LAD for the delay in the delivery of the vacant possession. The court allowed the application to reinstate, even though Hemmelata was not a director of the company, was not a shareholder. So Hemmelata in this case was an aggrieved party, like what I've mentioned in my previous slide. So yes, Justice Hasna allowed in this case. So what is the procedure for reinstating a company after we have heard all this? So what is the procedure? So pursuant to Order 88, Rule 2 of the Rules of Court, an application to reinstate the name of a company must be done in the following manner: to file in an originating summons and an affidavit in support with all the relevant reasons and evidence as to why the reinstatement should be done. So basically in the affidavit in support, we have to state why do you want the company to be reinstated? What are the reasons? So, and all these reasons would have to be substantiated with evidence. So if the reason for reinstatement is that the company was still in operation at the time of striking off, such evidence must be included. So here you have to show financial statements, annual reports, and to be included and exhibited. If there are assets still in existence at the time of the striking off, evidence of the same must also be adduced. This could include bank accounts, vehicle registration forms, and even land titles. So let's say subsequently after we have served the cost papers, the OS and the affidavit in support to the SSM, for example. SSM may in return also require more evidence or documents from the petitioner here or the applicant here to justify the reasons why it needs to be reinstated. I come to the end of my presentation and we will take questions from here.
Thank you, Ryan and Gan, for the presentation. We will now take questions from Slido. Right. Are you all on the Slido page?
Yes.
Yes. So the first question that we have here: if a struck-off company by SSM but continues to operate and owes money, can the said company be sued?
John, I will take this question. If a company that has been struck off by SSM and continues to operate, I think that is illegal. Once a company has been struck off by SSM, they are not supposed to operate. And let's say for some reasons they are still in operation, can you actually sue the company? Well, I believe if that's the case, you have to lodge this to SSM to tell them that after being struck off, the company is still in operation. Because if a company that has been struck off, there is no more entity for you to sue. So hence, resolution here would be you have to tell SSM what is happening. And if that's the case, you would have to sue to reinstate the company once it's reinstated and then to sue for whatever is owing.
Thank you, Gan.
Yes.
Next question is: what happens if a company that has been struck off continues to operate?
I can take this question. A company that has been struck off cannot continue to operate. As what Gan said, essentially to strike off a company, you have to show that the company is no longer in operation. There's no more business transactions. Only then can a company be struck off. If a company continues to operate after it has been struck off, like what Gan said, you should lodge a complaint to the SSM. It should not happen and it is illegal to do so.
Thank you, Ryan. Next question: does the striking off apply to a sole proprietor?
I will answer this. No, it doesn't. The striking off that we are concerned here today falls under the Companies Act. So sole proprietor doesn't fall under the Companies Act.
Next question. After the company is reinstated, the company does not have to pay the applicable charges for registration of company. Is this correct, Gan or Ryan?
I will take this. Once the company has been reinstated or let's say you've put in the application and of course you have to serve it on SSM. So there would be some form of fees that is payable. SSM will require some fees, administration fees, to have it reinstated. So yes, there are applicable charges for reinstating the company.
Thank you.
If I could just add, the applicable charges for reinstating a company, from what I've seen, is usually 2,000 as administration fees paid to SSM.
That would be for the striking off?
No, after you reinstate a company, you will have to pay an administration fee to SSM in the region of 2,000.
Okay. And would that apply to this question as well? Is there any charge applicable to reinstate a company?
Yes, it's applicable to that.
Thank you. Next question. How long is the duration for striking off a company takes place, estimated?
I'll take this question. So once you file in your declaration and checklist of requirements to SSM, they will take about 2 weeks to process the application forms. And from then on, the 30 days of allowing aggrieved persons to object will start. So after the 30 days is up, the company will be struck off and it will be gazetted. So all in all, it will take about 6 to 7 weeks for a company to be struck off.
Okay, next question. Does the company need to file its latest annual return and financial statement before being struck off?
Yes, I can take this one. I guess it depends who is striking out. If the SSM on its own volition is going to strike out, then I think you do not need to file the latest annual return and financial statements. But if the director or even the shareholders of the company decides on its own motion that they want to apply to have the companies struck off the roll, then yes, there are certain documents that has to be filed, which is inclusive of this, the annual returns and financial statements to the SSM. And upon having all these statements, then SSM will follow all the other procedures, like the notices and the others, and then apply and then have it struck off the register.
Okay, thank you, Gan. Okay, looks like we have no more questions. Thank you, Ryan and Gan, for your insights. Before we end this talk, there are a few announcements that I would like to make. Firstly, please do join us again for our upcoming talks. Our next talk will be on the 2nd of June, 2021. The topic will be Introduction to the Strata Management Tribunal. And my colleague Celine Tay and myself will be speaking on this topic. Secondly, please fill in our feedback form and tell us what you thought of our talk today. The link to the form will be posted in the chat box in Zoom. Thirdly, feel free to follow or like our social media accounts. We are on YouTube, Twitter, Instagram, LinkedIn, and Facebook, where we regularly post useful infographics on the law in Malaysia. Fourthly, if you would like to speak with any of our lawyers, we offer a complimentary 30-minute consultation over the telephone or over video conference. Please fill in the form on our website, and the link is also posted in the chat box. To our attendees today, our guests, thank you so much for joining us. We hope you have found today's session informative and useful.
Thank you, everyone.